I'm almost done. You are here during my concluding remarks. Fantastic. Okay. But you can borrow from him what I said. Okay. Yes. Then we've observed, I'm almost done. In the next 6-7 minutes, maximum 10, I'll be done. Then we observe clause 4. Clause 4, subclause 2G, which again relates to powers and functions of the IEC. Again, I started talking a bit about it during the period I looked at clause 88. But here, our beef again here is really the issuing of permits for political party campaigns, processions, and rallies. Okay, why am I saying that? I have mentioned again, we know section 25, which talks about, which guarantees the right to freedom of assembly, including the right of political parties to hold rallies, subjecting the exercise to this right to the authority of permit. Authority of permit may hinder its enjoyment. So what are we suggesting? We're suggesting that the law be put in place so that what will be required is a notification regime to allow the state to facilitate the exercise of this right. Usually when we say notification, people believe that then we're saying that anybody can just get up and do anything. No. The issue of notification makes it easier. You're notifying rather than requesting, as was the problem. You request as if you are begging. Request, and this is a fundamental right. So let us look at the nomenclature and look at what also happens in other countries. Look at we've done, as I said, we've done an advisory note on issues relating to notification and request, which we will also avail to this to the National Assembly when we go back. And we felt therefore that this will be in line, changing the nomenclature, issuing of permits should be the decisions. They make a decision. You notify, and a decision will be made based on, as we say, no, you cannot on this day because Honorable Mahdi's party is at the same time, at the same venue, they will be there. So we'll have to readjust it to another time. So, so this is it. So let us look at also the wording, because words have a lot of meaning, especially in the democratic process and where we are trying to move to. And again, looking at our context and where we are coming from. So section 140, we looked at. We read it together. Sorry, clause 140, that is talk about results of referendum. We read it together with clause 141. And we saw it says, clause 141 says, the referendum question shall be determined by a simple majority of the votes cast at the referendum. Fine. This is very clear. And then we looked at section, clause 141. It says, where no side obtains required majority, where no side obtains the majority required to, in section 140, the position prevailing before the referendum and in respect to which a decision by way of referendum was sought shall remain. Are we seeing a problem here? Is there any relevance to clause 141? It's determined. You either have a simple majority or not. We just thought that it's tautologous. We're overflogging the issue. It says it shall be determined by a simple majority. So if you don't have a simple majority, it's for just, well, let's again look at it. It's there. I don't know why it was there. Maybe it's an overkill, just or a copy and paste or whatever. But it's very simple. The referendum question shall be determined by a simple majority of the votes cast at the referendum.
But isn't this provision a little bit in contradiction with the Constitution when it comes to certain referendums? Because some referendums, there must be a percentage that has to be passed before it can change. For example,
Entering clauses.
a constitutional referendum.
Yes.
I think this The provision itself needs to be looked at.
Yes, but let's look at, because it talks about for which, okay, let's read it again. Where no side obtains a majority referred to in section 140. So 140
itself,
yes,
might be in contravention with the
and you are very right. You are very right, and I'm happy you picked it up again, although we didn't mention it, because if you look at when we go to referendum, some entrenched clauses, it tells you it has to be 3/4 or whatever in order to change it. So So again, these are clauses that needs to be revisited so that they will not be one, as I said, 1 for 1, even by its very nature, didn't make sense. And then also let us cross-reference it to provisions of our to see whether what we're trying to do here doesn't affect those entrenched clauses. So that will be, so we can say cross-reference with 1997 Constitution. Okay. The other one is just a minor point that we saw. It's clause 68. Clause 68, it talks about priority of voting in the casting of votes. The presiding officer shall give priority to, and it's very fine. Everything written there, it's fine. We just says that instead of saying on subclause C, persons with disability, persons with disabilities. Yeah, it's just a minor. We've also seen a similar, perhaps maybe a typing error or just not putting things there. Clause, if you look at clause 25, subclause 2B, it talks about prepare A, and then there is a gap there. Prepare A and then gap of the voter card as set out in Form 22 in the third schedule. So I think it's probably referring to the counterfoil. As something is missing in the sentence, I think it's the counterfoil. So let us also put it there. I have mentioned the interpretation section, which is very short. It can be beefed up to look at definition of some of those sections. We can look at the election acts of other countries where you have a longer interpretation of clause of processions, demonstration, rallies. So it can help us so that we can avoid possible doubts. But what we also thought about, and it's not here in the bill itself, but we thought about why not have a clause talking about elections of the presidency or a 50+1 second round of voting. I don't think you need to go to a referendum now to have that, do you? The election bill could have had it. It was just a discussion that we had, and we know that it was removed. It was there once upon a time, but it was removed because it was also not an entrenched clause in our constitution. Yes, I remember the 2002 6 election. It was after that it was amended. The fifth, but no, we're trying to import a clause that is not here. We were just being exuberant. That's the word. Yes. Okay. The proposal is this. We've looked at the Election Act. We've went through a lot of issues, but we just thought that why can't the election bill has the 50+1 for the presidential election? You know, we looked at it. It was once upon a time, I know, in the Constitution. Then it was removed because it was easily removed. It was not an end. What stops the bill of saying that? And then we listened to the debates. It was just something we thought about.
How can we do that in the bill? Doesn't it require any constitutional?
Well, for that one, we're not talking about the term limits. You know, certain things. We were just thinking, and what stops the bill? It talks about the voting. It talks about many things, about thresholds, about deposits. I see, or we see, no obstacle we stand to be corrected. As we know, law is very fluid. But we stand to be corrected to say, well, why not? We have to be creative. Again, it's just a why not. We leave it to the parliamentarians. You are the people with the powers. And so we just thought about the why not. So let's take it as a takeaway. Because we just looked at it, there is nowhere in the Constitution which it was amended once upon a time, and it took a simple amendment to be done. So yes. Yes. Yes, but Commissioner Dan, I think you are more afraid with that. Can you shed light? No. Yes, I remember we talked about it. Yes. Something like that, yes. And I didn't even have the act. Yeah.
You say once upon a time. It was
No, he is just
yes. Yes. Yes.
This is a modification.
Yes.
So you are asking why you said that when it was a constitution, it was taken to the National Assembly for amendment.
Yes.
Yeah, okay. What I would say,
It was amended in 2003.
it was amended in
2003, yes. Right, National Assembly.
just after that election, which was very close. I think he almost went to a second round. So it's not there. So the argument we are making is that so we are not talking about contravention, because we know there is a hierarchy of laws. If it was there and it's proposed, of course it will be out. But it's not in the Constitution anymore. It was removed. And if you look at the election bill, it covers. Yes.
In which constitution was it, and when?
Yes.
Okay. So
Seni, please, counsel, read it, but not in your sub voice, loud. Yes, it's the 1997 Constitution, and after the
1997 Constitution.
Yes, after the but it was amended in 2003. After that election, that was close. It was a very close election where he had 51 point something, almost 52%. So it was very close, and they just decided, listen, we don't want trouble. We're going to remove it. It's not there.
It's 48 sub 3.
48 sub 3.
Yeah.
I remember the first referendum of the Republican status. We did not achieve the required threshold. And then it failed, of course, and then we went back. So that's why I'm asking.
Or did they say that it will now be just simple majority?
Yes, that is with the presidency issue.
Yeah.
Your proposal, I don't think it can be possible.
Okay.
48.3 is saying no person is elected as president on the first ballot unless he or she receives the highest number of votes validly cast at the election. That means if he or she receives a simple majority, he would automatically be president. You cannot change that in the acting state.
Was the constitution?
Yes.
No. I think I was on a fishing expedition. I know the provision was removed, but it seems quickly that they now replace it as.
That's an act number 12 of 2003.
So 2003 was the.
So that's, I think the whole emphasis that it's not an entering clause.
Yes. But if it is not an entering clause, yes.
If it is changed by an act, it can also be modified by an act.
Yeah.
So I think that's the question.
Yeah.
Then the simple majority
Is there, okay.
once it is in the constitution.
Yes. Unless you amend that provision, and then, yeah. Although it's even by a simple majority, it won't be amended. That's what I'm saying. If you read the two together, if my proposal was there, you read the two together. Okay. So, Madam Honorable Speaker, I think you will understand that it's good to try and look at these provisions and see how to improve things. So, yes. Yes. You mentioned, you remember, we talked about the death. And, no.
Death of an independent.
Yes. What was the provision again? Because then you gave us an advice as to, yeah. Seni, if you remember the reason.
Section 54, clause 54.
Yes.
Section 54? Or is in the clause?
No, we didn't. No, we didn't touch that. That's why I was saying that it will also be good. It's not. Okay. Oh yeah. Yeah, but of course, as you know, a lot of people have raised queries on that. That is too long a period. Yeah, but okay, we didn't, as I said, we didn't look at human rights, but it is a long period, a big gap between that period and the voting itself. Yes. So,
they can throw them.
yeah, they can throw them. Some of it we will sit and discuss. And in fact, they should have sent it to us earlier. The passage of this bill. Yes.
When the committee finalized for it to go back
Yes.
to plenary,
Yes.
and then the process be completed and again finalized and eventually passed for it to be accepted for it to come to law.
No, and we have actually raised that, but at least in the context of the diasporan vote, you heard what I said, because the timetable is very short, extremely short for a lot of these processes to happen, and that is why there is a lot of cynicism that will we even have an election?
Interesting, just for you to know, we were told by the IEC that they intend to use the whole
If this fails.
No, because of the timeline.
Well, that's I mean, because
They are planning on registering the 29th of this month, and this bill would likely not pass before the 29th.
okay, so they use the provision of the existing law.
Which is going to be of issues because that law doesn't address a lot of things that this one is addressing, and with the things you are bringing on board. So, for example, the prisoner issue, if they register with the old act, that means the prisoners will not have a chance because by the time we haven't changed it. So these are the little bit, what we can do to fasten the process is the big question mark.
Yeah.
So that we can go to registration with this law instead of the already
Existing law, yeah.
So that is
And this, unfortunately, these are processes that it's between IEC and the National Assembly and the government.
have you
Yeah, we have what we wanted. Would you want to talk on it? No. Oh, yeah, okay. Yeah, we have concluded, and but I will also want if we can have a copy of those questionnaires, because we are also curious to look at it. Yes, to give us a copy, and then we will also.
So maybe you just go through the questionnaire, and if there's anything you haven't addressed that is in the questionnaire, and you would like to address it, and we can.
Yes. Oh, you can also ask questions.
So we ask the
Yes, yes.
honorable members, or you can ask the questions on the questionnaire.
It's good that we had the questions.
questions. Want to take it, have a look at it, put it down, use it to write it, and then forward it. By Monday.
Clarifications on the daily
Then
action.
you need to ask the questions. Yes, if you have any questions.
Go ahead. Yes, they want to take clarifications on the submission. I'll give honorable to them and then I'll.
So, yes, Yes. Yes. I just want to say the threshold of 40% for the president is already a constitutional provision. So it's like, it's already in the constitution. It requires an amendment before we can change it. But from your reaction, I want to ask this question. You know, Section 26 of the Constitution emphasizes there should not be unreasonable restrictions when it comes to voting. So, during the conduct of public elections or public events. So, what is your take on clause 67.4? You know, 67.4, which is dealing with assisted voters.
Yes.
Okay, shall assist a voter only once. If a voter can only assist another voter only once. But we know in some communities, they are hamlets. Voters may only trust one person. For example, 3 voters may trust one person. But if you say that person can only assist only one person, and these are disabled people who will require some assistance, how do you see that? I was thinking there is a human rights situation.
Yeah, and this I will also, because these are questions that, as you know, they are not just legal. Yeah. These are questions, it has to do with trust, yes. It has to do with the community. Yes. So it says a person who assists a voter under this part shall assist only one voter in any one election. So if, for example, the voter, as you rightly said, has confidence and trust, and I'm sure there is a reason what they are trying to avoid here.
I think
there must be a reason why they are saying a person who assists a voter under this part shall assist only one voter, so that you will probably not have maybe a party stalwart, because assisting, trying to make sure that this person votes for this particular candidate throughout. Should we, in situations where there is a difference, why can't we say that we'll leave it to the voter who the voter trusts?
That is the practice. Now they are saying only once.
Well, that's what I'm saying. Then perhaps we should think about it and say that someone that the voter trusts, because this is somebody you trust.
Yes.
Yeah. But you trust this. Yeah.
Now I'm saying you can have a family where probably you have 3 persons with disabilities, and you have only one able person member who they trust.
Yeah.
So if you restrict it only to one, then I think that could be problematic.
From practice that.
Yeah. So yeah, 67, and that was 67.
Thank you. But I want to give Honorable Nayas on this issue to give our opinion.
Yes, it was an experience that I had, because there was a time when I went to the polling station and somebody was assisting me. Mm-hmm. So, but I knew that what he did for me was not right. So I asked him to show me only the polling booths, that who is number 1, who is number 2, who is number 3. Then he gave me, number 1 is this, number 2 is this, number 3 is this. Then I asked him to leave. So he left, and then I called him back. He came and I asked him, who is number 1? He gave me a different answer. Who is number 2? That is why I say, if they are doing these things, let them invite us. We know how to go about it.
And it's also important, therefore, to get somebody that you trust.
Yes.
That's the point.
In fact, that is what had happened. So the next election, when I was going, I even went with somebody I trust, and I asked him to show me who is number 1, number 2, number 3, and then I asked him to leave, because I don't want him to know who I am voting for.
And also, Honorable Speaker, I mentioned earlier about the assistant. You remember, it was one of the things we said. Why don't you have, for someone like her, if the ballots had a sticker with Braille, it will be easy. You'll go and then, do you know what I'm saying? Yes. Yeah. So that was what we were saying, that shall assist. You know, it was not just good enough. Assistance should also mean, yeah. So having Braille and other things. So okay. So it's an area that we perhaps needs to. The emphasis should not just be one person. The emphasis should be the trust of the person, because you know, if I tell Commissioner Mokhtar Babali that this is where I want, he will put it there. Huh? Yeah, it's trust, and it will be between himself and God.
Yes, mine is another question. It's like you say in the bill, clause 107, registration of political parties, participation of political parties in elections, and sub-clause 7, political parties shall endeavor to encourage women participation in their executive membership. I think I am also suggesting these should not only be limited to women, but again, like I'm representing two entities in the parliament. Yes, the people of Tumana constituency and the entire youth fraternity of this country. Yeah. So I believe the youth also should be included. Yeah, it should also capture the youth section too, as well.
Okay.
Yeah, that's a suggestion.
Another question.
Okay, that's okay.
You're doing bad because we, in that particular provision,
yes.
In that particular provision, we mentioned, I think our bone of contention there was to have not just to have, say, shall endeavor, but to have a percentage, yes. So you're suggesting that they should also, the executive members must be forced to have this percentage of youth.
The same for the system, at least 30%, yes, that's okay. Yeah.
I think we should first have that in the assembly before we move it to political parties.
What do you mean? Yes.
Okay. Do I have another question? Okay, Mr. Stanley. Then I'll continue.
Thank you very much, Honorable Co-Chair. So you've clause 5 of the bill, subsection 1, that is talking about appointment of electoral officers.
Yes.
One is talking about the commission shall appoint a chief electoral officer,
yes,
who shall hold office on terms and conditions specified in his or her letter of appointment.
yes.
And you are suggesting at least 5 years. Like these are very delicate position and important position too.
Yes.
Like I'm thinking in that, like, if we can, if there is it possible to adjust it from 5 to probably 6 or up to 10 years by the virtue of the experience you accrue in this particular position too, rather than recruiting depending on recruiting every time.
Yes. So if you remember, well, it's something that we looked at here.
Yes.
And we said that the position is a very important position. It's a very senior position, and just stating that the commission shall appoint the chief electoral officer who shall hold office on terms and conditions specified in his or her letter, without stating the term. It's not correct. And we even, I read for you the section of our executive secretary. Yes, section 9 is to do with removal. Yeah. Yes, we have a fixed term. So all this is there, but it says he shall hold an office for a term of 5 years, renewable. That's why I proffered that would solve this problem, because you need to give this particular person security of tenure. This is the commission. Yes. Like, for example, the appointing commission.
Who appoints your executive?
Yeah, exactly. That's how I was going to come to it straight away. We are the appointing officers, of course, with certain guidelines, and that you are. But it says, but the act, like, it says that the executive secretary shall hold office for 5 years on such terms and conditions as shall be determined by the commission, and he or she is eligible for appointment for one further term. You see, they have that but they removed. There is no term. It could be for 3 months. It could be for 6 months. And we just felt that there needs to be security of tenure. That's what we That's what we propose that perhaps should be added. Yes. And also, of course, when you will have it, the removal, it's also, yeah, there's a lot of gaps. So, yeah, thank you for putting this
So
on.
if we take your emphasis for your survey is on tenure.
Not only tenure, you were not here, but also removal. Yes, but also the removal is open to big abuse. Oh yeah, it's got of tenure, exactly. Yes, yes. Thank you very much. You're right.
Yes, you talk about diaspora bodies.
Yes,
you talk about diaspora bodies with prisons, imprisonment, the right of body prisons.
There are two different things.
Yes.
Which one? Okay.
I'm going on. What about those people in diaspora serving in prison in diaspora? What is your take? Those people in diaspora.
Well, diasporans, the question is this. Since we are advocating, I'm trying to paraphrase what you say.
Yes.
Since right to vote for prisoners, yes, or at least categories of prisoners. We gave you what happens in other places. What will be prisoners in well, if we give the right, then it means we give the right. But of course, I can foresee logistics problems happening. I think this is what the problem will be. If they're out there, but the IEC can work out something. If it is in the law, then it's up to the IEC to make sure that is done well before. You know, you can have voting by, you know, before. So it can be arranged. But when we say that right is given, it's everybody. Why? But you want to say something? Yeah. Yeah. Yeah.
Human rights fighters, those people sick patients on hospitals, on beds. What is your take on those?
Yeah, they should be assisted to vote. They should be assisted to vote, and it happens where you actually make provision so that they can vote.
What is your stand? Because you give the opportunity. I think you are giving the opportunity.
Yes. Yes, we can include them, but we didn't specifically think about those who are bedridden. I have to be honest. You know, you can't think of all the circumstances at the time. So the categories that we're thinking of, we're not thinking about those who are bedridden, for example. But if you ask us, yes, they should be assisted, and so that they will be able to vote. The right to vote is very fundamental. Yes, it would have been easy, of course. I know. Yes. And of course, as we know, there are a lot of advantages in the marble, but at the same time, there are disadvantages. Some of the things you have mentioned would have been easily done exactly. So these are the gives and takes. Yeah.
Okay, thank you very much. When it comes to postponement of elections in the bill, when a political party candidate died, will be postponed. Yeah. But when it is an independent candidate, the election will go on. So I just want to know what is your take on that.
Okay, come again.
Say, when it comes to postponement of elections,
yes,
if a political party candidate dies,
yes,
elections are postponed.
Elections are postponed.
It is postponed, yes.
Yes, and then
an independent candidate dies, the elections proceeds.
Yes, it was raised yesterday. Now you're refreshing my memory, and one of our council, we had a debate on it. I think Commissioner David even raised it. But for political party, it's structured. They'll go, they'll organize, they'll have their candidate. An independent is an independent. You know, we cannot say that let's wait for his son who is in America to come and stand. An independent person is different. So what are we waiting for? Are we consulting political parties? Sorry?
I think someone
Yeah. So this is the rationale that was brought to us, and to us it made sense. It made sense really that you're dealing with political party organization, but if it is independent, let's move on. Let's give choice again out to the people who are there. But yeah, it's not fair. Why is it not fair, Honorable? Huh? No, no. If you say it's not fair, I am saying it's fair. Convince me that it's not fair.
It's very fair.
Postpone the elections. How are we sure that we're not independent candidates?
Yeah. Huh. They don't have a party. They don't have, yeah. No, I find it.
I would allow Honorable to do it.
Thank you. The mindset is, for example, postponing the election for another candidate to come. But in a scenario where you have a party candidate, only one party candidate, and then only one independent candidate, and they go into election, then during the period the independent candidate dies. Then if you don't postpone the election, it means that automatically the party candidate becomes independent. So that scenario also people are thinking of. So let's think along those lines.
Mr. Chairman.
Yes.
Still on the diaspora.
Yes.
I want a clarification on whether those Gambians that have dual citizenship and have a voting right in Europe can also have a right to vote in the country.
Yes. I think the only restrictions on them would be holding of certain positions like the presidency, you know, and for obvious reasons. So, yeah. But the right to vote, I've known people to vote. Yeah. And there was something that we omitted, but well, that I omitted, not we, since I'm the spokesperson, I take responsibility here. We looked at representation of the people. No, I don't know why I didn't print it, but anyway, maybe it was page 10. It never came out. So, Madam Honorable Speaker, we looked at the way in which constituencies are demarcated. And I know it could be a thorny issue, but we looked at, for example, 3 sets of constituency. One is Banjul, Banjul North, Banjul Central, Banjul South. We also looked at Janjanbureh. Then we looked at the combos. Usually, when you demarcate boundaries, it has to be both geographical and population, because that is how we talk about representation. So that people will say that, well, we are properly represented. But if you look at the voter population in Janjanbureh, and you look at the Combo South, the Combo North, or the Banjuls, are we really having equal representation? So we just looked at it and said, well, I think perhaps, I think it's in part 1 schedule, in one of the schedule, where it lists. And when we look at it, we just felt that, well, it's in the first schedule, part 2, the constituency boundaries. If you look at Janjanbureh, Banjul South, Banjul Central, Banjul North, we just felt that perhaps redemarcation of this constituency should be considered. Otherwise, it's really, we're not just saying, sometimes it's even outrageous. You know, you cannot have fixed But, you know, reasonable, but this was not reasonable. So we just thought that we'll flag that. And another thing that, yes, I think I missed these 2 points. Another one that we looked at, again, it's to do with registration of political parties. Clause 107, which says that 3/4 of the party executive members must be permanent residents of the Gambia. Okay. This provision, the existing Section 5 of the Election Amendment Act 2015 requires that all political party executives to be resident in the Gambia. If you remember, this was overruled by a Supreme Court decision in the case of Bakari Bunja Dabo and 4 others. So therefore, you cannot have all. It says it was unconstitutional because it offended, I think, Section 41 dealing with electoral laws and Section 60 of political parties of our Constitution. But 3/4, are we also not overflogging the issue here? Some constitutional provision, especially if there is a Supreme Court decision on this matter, saying that it's flouted the very these sections in our Constitution. So I believe that they should look at it. 3/4, again, I think is a big threshold high. So we just thought that we need to flag that as well. Yes, we have that in our paper.
I want to make clear.
Is it on the same issue you raised?
No, remember for Dalini from Rajawar, he put a question to the...
Yes.
That the diaspora is like, for instance, the Gambian has 2 passports.
Yes.
And he has the right to vote in America.
Yes.
For instance. And the same person also have the right to vote in Gambia.
Yes.
You mean he said yes?
Yes, we said that, yes. And it happens. This is not new. In most countries, it happens. And it's, yeah, dual citizen, people are... Yeah, it's correct. Yeah.
I have a question on the issue of section clause 88.
Oh.
Yes. You told us that it is best practice that notices are given instead of requests for permits.
Yes.
I just want you to be in line with the existing Public Order Act. What this seems to be doing is removing the right of the police when it is in relation to political parties, demonstration, procession, and as your suggestion rallies, removing the right of requesting permit from the IGP and giving it to the IEC. That is what this,
as far as political
parties are concerned.
Yes.
That is what this seems to be doing.
Yes.
So just legally, in my mind, it's like when this becomes law, that means political parties no longer have to go to the IGP to request.
This is what we're suggesting.
Yes.
But remember, in the provisions, I think in the 40s, it talks about the IEC liaising with the office of the IGP. So it's, you know, and for obvious reasons. But the power lies with the IEC, not the IGP.
So when this comes to law, it takes precedence.
It will naturally take precedence. Yes. This is what we are saying. But also, we looking at the provision, the word rally is missing. And we feel that rally should also be, yeah.
Okay, so that's important. I think given the problems we have with the Public Order Act,
Yes.
this is one way to immediately solve the problem in relation to political.
Yes, political parties. If the IEC is there, they will liaise. There's nothing saying that they cannot liaise. It's the law is there. You know, you talk to them, talk to the IGP, we're going to so and so. They can even give more and tell you, give you advice that this particular area at this time, it's there.
That simplifies everything.
Yes.
You know, during the election period,
Yes.
the IEC takes over whole process of election.
Yes.
Campaign, everything.
Yes.
So they make a schedule for when they are going to vote. You make your own schedule, and then political parties will meet at the IEC and they will trust out. So that they leave places for each other. So that those rallies are taken care of through that process. That's why they don't put mention rallies here. So this procession and demonstrations are separately put, in the draft, so that they are not mixing rallies with demonstrations.
But do you know that throughout the act, when we look, I don't know for whatever reason, they talk about procession, demonstration, and they leave out rallies.
No, rallies are mentioned.
Yeah.
They are there.
So
they are mentioned. They are mentioned. They are catered for.
Where?
Yes, they are catered for.
Because if you look at holding a demonstration or procession, and you look at what they are actually talking about during this period, these are just rallies. Either you're holding demonstration, yes, is one of it, but most of the period is for rally purposes. And we were just wondering why, and then when you look at other elections act, rally comes there. It's rally because that's what they do. But anyway, look at it again. We didn't see rally, and that was why we mentioned it from section.
I'll show you where rallies are taken.
Yeah, just cite it. It's section 4, clause 4. What does clause 4 say?
Clause 4, subsection 3.
Yes.
Rallies are taken.
Makes reference to rallies.
Yes.
Not as regulated. Not mentioned as
rallies are taken separately.
Yeah, but if you look at section, what section 88 is talking about is this process during the campaign, demo procession. Why not rally? It's still looking for that. Yeah, so they can borrow that rally is, we've seen where it's mentioned. It's just talk, but all the things that it is talking about is also talking about here. Why are you omitting rallies? Section 4. By the way, you look at it, the rallies was just mentioned in passing here when it comes to political with permits. And then it's further omitted in the whole of section 88 and the other sections that we've looked at.
Probably one whenever
I don't know how it is.
Demonstration, procession, and rallies. This is what happens during the election period. That's what we said. Just insert so that there is no ambiguity. Again, what are we trying to safeguard? We don't want to say that, well, yeah, this was a rally, and under this there can be a rally. The whole idea was to get towards a rally.
And my second issue is the issue of the voting for prisoners, and
Yes.
this is a human rights issue.
Yes.
And I was thinking while you were speaking that when this right to vote, it's giving to a Gambian citizen when you are 18 and of sound mind.
Yes.
There is no condition. When it comes to the Constitution doesn't say if you are in prison you cannot vote.
Yeah.
Can the election bill say this? Wouldn't that be in contradiction in contravention of the Constitution? Because that provision could have said that the Constitution could have gone ahead and list the categories of people that cannot vote. Normally that's what it does if it wants to exclude, it lists. But the law as it is now does not exclude anyone who is 18 and of sound mind, whether you're in prison or whether you are sick. It does not. So can we even have this in our bill in the first place? That is a human rights issue, I think.
Well, you've even gone far.
Yes.
You've even gone, welcome to our camp. Yesterday, some of the commissioners made us spirited.
Yeah.
Because I was even leaning, in the event, let us even look at categories of prisoners. That's why I even mentioned. In the UK, for example, there are people in prison I've mentioned who, because it's debt, fulfillment of maybe not, that funny law that we have, civil debts, and also not fulfilling fines that are paid. And I've also mentioned there are those who are not even sentenced. They've been in remand for long. But the other point is this. The Constitution has not even excluded them. So, in other words, by excluding them, to borrow your brief, we're even flouting their fundamental right because the Constitution has not excluded them. Good point. We're with you all the way, Honorable.
So
Yeah.
kind of
Yes, and not only that, Honorable Speaker, you were not here. And it was drawn to our attention, and I actually checked it. In the Ghana presidential election of 2020, the ballot boxes were brought to the prison. They all voted. Yes, they all voted. You can check. We went to it, and we're talking about a couple of months ago. They voted. So, Commissioner Ghana, you're winning this one.
Sorry for coming late. It might have to address that are towards, for example, towards the end of their terms. And elections, we have elections every 5 years, and we have elections today, and you are expecting release in a few months. Don't you have a right to vote in that sense?
I actually categorically mentioned this, but what I did was a blanket right to vote. And then I said, in the event, we don't. And I gave reasons why. You have these categories of prisoners exactly as mentioned. Those that they're serving term, but by December they'll be out. But during the period of this registration, they'll be in. So we're disenfranchising them. So we agree with you.
But I think our point was, when we were discussing it, as Honorable Jim said, is that a right to vote is inalienable. Prisoners should, every category, because should have that right, because to vote is about your nation. It's about your vote in how even the prison is administered. So if we exclude prisoners, then we are also excluding them from having a say in how the prison is administered. So I think for me, really, that right should be extended to all. I'm not sure what prevails right now, but I think our next engagement with the IPC, this is so that the prisoners have a right to
Yes.
Everybody's place.
But you know what is even worrying us is that you even have a category of prisoners who are not sentenced because they say sentence. They're in remand. And and we know what happened. You can be in remand for a very long period. Exactly. So these are issues that we felt that we really needed to raise. Yeah.
I just want to make a correction. Honorable Speaker brought in Kemesen's case as an example. Kemesen, in this case, do not have a right because his nomination documents were smuggled to him in the police station. And when it was discovered, the entire hierarchy of that police and the Farafenni police were in trouble. So it wasn't like a right given to him. So that could not be a better example. The nomination documents were smuggled to him.
So we don't want to be smuggling nomination documents.
We don't.
Yes. Okay. And I will not ask who smuggled it. I don't want to implication.
Yes. Commissioner, let's look at clause 68. Clause 68, which is priority of voting. Let's look at it closely. I was thinking that we may need an E.
An E.
Which will deal with the sick. Sometimes you are sick, but you are able to vote.
Yes.
So if those sick people come, don't you think they need to be given priority?
Okay, those who are priority.
They have elderly and the sick.
Elderly and the sick.
If we put them together.
Yes. It says the candidate contesting the elections, pregnant or lactating women, persons with that's why I said persons, there I said we should change and put persons with disabilities and the elderly. So we can add the sick and the elderly, because disabilities may not just mean sickness, but of course if you are sick, you are yes. So it can be, good question, we can add persons who are sick and persons with disabilities and the elderly. Yes. Yeah.
I think this brings us to the end.
Yes.
To express our gratitude, the gratitude of the Assembly towards the National Human Rights Commission. This is one session that I really enjoyed. I enjoyed your briefing. It was very clear and detailed, and you raised a lot of issues that normally us looking at it wouldn't have been able to see. So thank you very much. We really appreciate it.
and we have the questionnaire. If there's anything else, we'll convene a meeting and we will, yeah, definitely. Yes.